Section 2. Ms. DeNovo, you have an amendment?
I do. Thank you, Mr. Chair. I move that Section 2 of the bill be amended by adding the following subsection 0.1, the definition of quotes unquote pit bull in subsection 1 of the Dog Owners Liability Act is repealed. Again, I think this is in keeping with the spirit of the bill. There's no need for breed-specific references in either the DOLA or ARA, so we've removed references to pit bulls and definitions.
Okay. Any commentary? Debate? There being none, carried.
Mr. We will not be supporting that amendment.
Okay. Thank you. And call for a vote. All those in favor? Opposed? Carried. No? Ladies and gentlemen, yes, I do get to vote, and since it's a casting vote, and since there is procedure on this, I cannot, in fact, cast a vote in favor of your amendment. And thus, the amendment fails.
May I have a comment? I know the vote's already been cast, and the same with yours. But may I make a comment?
Please.
Just for the committee, it was clearly demonstrated through the committee hearings by all experts that there is no such thing as a pit bull, and there is no way to identify a pit bull. Okay, yeah. And the vote.
Mr. Chair, if there's 5 voting in favor of it and 4, is there 1 vote less? Okay. Sorry, I was a bit confused there. Okay.
Excuse me, point of order, Mr. Chair. Perhaps you could explain, just for those here, why you had to vote the way you do.
I'll explain at the end.
Okay.
We voted.
So,
Due respect.
Next amendment.
To vote to move the bill.
Next amendment, Ms. DeNovo.
Yes. So I move that Section 2 of the bill be amended by adding the following subsection. 0.2, clauses 4, 1, B, and C of the Act are repealed and the following substituted. B, the dog has threatened a person or domestic animal with serious harm or created the reasonable apprehension of such threat. Or C, the owner did not exercise reasonable precautions to prevent the dog from 1, biting or attacking a person or domestic animal, or 2, threatening a person or domestic animal with serious harm or creating the reasonable apprehension of such a threat. And again, this is just adds to the spirit of the bill. Menace in current legislation is not clearly defined. It's open to interpretation. We have chosen to replace it with the more specific definition as a dog, quote, who has threatened a person or domestic animal with serious harm or created the reasonable apprehension of such a threat, unquote. It also keeps the emphasis with owner responsibility for not exercising reasonable precautions to prevent the dog from biting or threatening a domestic animal. These clauses are based on the Calgary model that we heard about in the hearings, but adapted to the provincial legislation.
Any debate? Any debate? Mr. Hillier?
Thank you very much. We'll be supporting this amendment. I do believe that the language provides greater clarity and consistent with, again, what we've heard through the committee process, but it does provide greater clarity to both the judiciary and also to people who would be enforcing this legislation with less subjectivity in place in a more objective manner.
Okay. Mr. Berardinetti?
We do not support the amendment.
Okay. Any further debate?
I'll have a recorded vote.
Recorded vote requested. All those in favor, please raise your hand.
Mr. Hillier, Mr. Nichols, Mr. Walker, Ms. DeNovo.
All those opposed?
Mr. Berardinetti, Mr. Coteau, Mr. Dillon, Mr. Sergio.
And as I'm required by custom and rule to vote against the change as the chair, I have to vote against that amendment, and thus the amendment fails.
Chair, maybe I could ask that we maybe put a motion on the floor that you not be so conventional today.
The motion is out of order. Thanks anyway. Amendment 3.
Sorry, I just want to make sure that I've got the right amendment here. I move that Section 2 of the bill be amended by adding the following subsection as 0.3. Subsection 4(3) of the Act is repealed and the following substituted. Final order. 3. Subject to subsection 3.1, if in a proceeding under subsection 1, the court finds that the dog has bitten or attacked a person or domestic animal, or that the dog has threatened a person or domestic animal with serious harm, or created the reasonable apprehension of such a threat, and if the court is satisfied that an order is necessary for the protection of the public, the court may order A, that the dog be destroyed in the manner specified in the order, or B, that the owner of the dog take the measures specified in the order for the more effective control of the dog or for purposes of public safety. Exceptions. 3.1, a court shall not make an order under subsection 3 if it finds that a dog, in taking the acts described in that subsection, was A, acting to defend its owner from attack or to prevent trespass or vandalism on its owner's property, or B, being subjected to terrorization. I'm not sure that's a word, Mr. Chair, but since the Liberals are going to vote against this anyway, I'll let it stand, and reacted in a reasonable manner to defend itself. I would have being subjected to abuse.
Do you have any other comments? No. Debate?
Again,
Mr. Hillier?
we will be supporting this amendment, and again, I think it is incumbent upon us all that legislation is provided and written in a fashion that gives very significant clarity to those who enforce the legislation, and that it not be subjected to, or that the ability to use a subjective view in the enforcement of the Act causes problems. And we've seen that with the present bill, that it's worded in such fashions that allows for injustice to happen. I think let's throw away the partisan cloaks here. Let's make sure, as this bill advances, that at the end of the day, the law enforcement and the judiciary both have a clear understanding of what the will of the legislature is and what specifically that the legislation addresses that specifically. So we will be supporting this amendment. I do hope and trust that the partisanship doesn't enter into the casting of votes any further on this.
Further debate? Mr. Berardinetti?
We will not be supporting the amendment.
Okay. Any other debate? There being none, recorded vote called for. All those in favor, please raise your hands.
Mr. Hillier, Mr. Nichols, Mr. Walker, Ms. DeNovo.
All those opposed?
Mr. Berardinetti, Mr. Coteau, Mr. Dillon, Mr. Sergio.
And as required, I have to vote against the amendment. We go to and thus the amendment fails. We go to Amendment 4. Ms. DeNovo?
Yes, I move that Section 2 of the bill be amended by adding the following subsection. 0.4, subsection 4 of the Act is amended by adding the following paragraph. 2.1, having a veterinarian licensed as such by the College of Veterinarians of Ontario implant in the dog an electronic identification microchip device recognized by the International Organization for Standardization to monitor the whereabouts of the dog. The purpose of this is for dogs that have been found to fit the description of quote-unquote vicious. It allows the court to implant a microchip in the dog that allows for the monitoring of the dog's whereabouts. Currently, every municipality keeps track of its vicious dogs. This amendment would ensure that the microchips that are implanted in dogs are of international standards that can be read by every municipality. It also opens the possibility of a provincial bite registry. Currently, we would not be able to introduce a bite registry because it it is beyond the scope of the bill, and it would also require additional detail to include in the registration. Ideally, though, under a provincial registry, we would be able to view when vicious dogs move to different municipalities and search for them in an online database.
Any debate on this? Mr. Hillier?
We'll be supporting this amendment once again. And I think, again, we have heard throughout those public hearings that additional options in this microchipping is that one more additional tool and option for society to know and have more details on animals that they ought to know about. I'll be interested in seeing the rationale and the reason why the Liberals will vote against this amendment.
Okay. Any other debate? There being no debate? Asking for a recorded vote. Thank you, Mr. Hillier. All those in favour, please raise their hands.
Mr. Hillier, Mr. Nichols, Mr. Walker, Ms. DeNovo.
All those opposed, please raise your hands.
Mr. Bertonetti, Mr. Coteau, Mr. Dillon, Mr. Sergio.
And again, as required by the rules, my ballot is cast against the amendment, and the amendment fails. Next amendment. Ms. DeNovo.
Thank you, Mr. Chair. I move that subsection 2.2 of the bill be struck out and the following substituted. Substitutions 4, 8, 9, and 10 of the Act are repealed, and the following substituted. Termination of order. 8. If the court has made an order under this section with respect to a dog, other than an order that the dog be destroyed, the owner of the dog may apply to the court to have the order terminated, and the court may terminate the order if A. No proceeding under subsection 1 has been commenced with respect to the dog since the order was made, and B. The order has been complied with, and C. It is satisfied on a reasonable basis that the dog is no longer a danger to the safety of persons or other animals. Amendment 5, the purpose of this, of course, is allowing an owner convicted under DOLA the opportunity to appeal, and if the owner is convicted under DOLA of owning a vicious dog, they should have the opportunity to appeal that conviction after a specified time period to be determined by the court. The owner may have taken part in obedience classes, obtained a CGN certificate, or achieved other results. The owner would then appear before a panel of experts, and it would encourage people to be better owners instead of just being punitive. I believe that makes some sense, both for the protection of humans and animals. And I would just add my voice, perhaps, to that of the Progressive Conservatives, to my literal and figurative right, and appeal to the Liberals to vote on their conscience and not along partisan lines. I would ask the member, Lorenzo Berardinetti, who seems to be so concerned about elephants, that perhaps he might be concerned about other animals as well. Thank you.
Further debate. Mr. Hillier?
Yeah, we'll again be supporting this amendment, and I think what we can clearly see what's happening today in this committee, in this clause-by-clause hearing, is that the Liberals are not serious about this legislation, and they're not serious about making good law in this province. That they're more interested, more interested in upholding party lines, and I guess that's why the member for Glengarry Prescott Russell was subbed off this committee earlier, and who indeed supported this bill at second reading, but now the party has subbed him out. Let's get with it, fellas. This is legislation that will impact the lives of the people in this province, the people that we represent. We ought to be doing something more than just representing our parties here when we're crafting up legislation.
Mr. Dillon?
It's not worth it.
No? Mr. Nichols?
Thank you very much, Mr. Chair. The apparent attacking both sides, I just have one question for the party opposite me, and I would ask that they would perhaps give us an explanation as to their reasoning as to why they're not in agreement with the amendments that are being made. No simply doesn't give us any direction. It just tells us it gives us the opportunity to think that perhaps they're just dead set against. I'd like to give them the opportunity to explain to us why what their rationale is for voting no against these, what we believe to be excellent amendments to this particular bill.
Is there any further debate? Mr. Broadnetti.
At the end of this session, I'll explain why, but at this point, we do not support this amendment.
Okay. Recorded vote has been requested. All those in favor of this amendment, please raise their hand.
Mr. Hillier, Mr. Nichols, Mr. Walker, Ms. DeNovo.
All those opposed?
Mr. Bertanetti, Mr. Coteau, Mr. Dillon, Mr. Sergio.
And my casting vote has to be against the amendment, thus it fails. And we go to Amendment 6. Ms. DeNovo.
Thank you, Mr. Chair. I move that subsection 2(6) of the bill, clause 19A of the Dog Owners Liability Act, I move that clause 19A of the Act as set out in subsection 2(6) of the bill be struck out. Again, this removes the term pit bull for this section of the bill. We have removed any reference to specific breeds under DOLA. In this section, the Act states that, quote, a document purporting to be signed by a member of the College of Veterinarians of Ontario stating that a dog is a pit bull within the meaning of this Act is receivable in evidence in a prosecution for a defense under this Act as proof. And it goes on. We're striking this clause out completely. And again, I know this is in the spirit of the bill that DOLA should apply to all dogs, not specific breeds. And I would just add, as way of explanation as well, along the line of some of the concerns that you've heard, that I would hope that the members opposite are representing their constituents, and I hope that they are fully aware of the Facebook sites and other sites of their constituents' signatures on petitions for this bill and for amending DOLA. And I hope that they would be ready to speak to those constituents about their actions here today.
Further debate? Mr. Hillier? Oh, I'm sorry. Mr. Hillier and then Mr. Broadnetti.
Once again, we'll be supporting this amendment. And once again, I will say to the members opposite in the Liberal Party that respect your roles here, respect your constituents, and this absolute towing of the party line and your refusal to improve or to work to improve legislation before you does a disservice not just to your constituents, it does a disservice to this institution. And man up and vote your conscience.
Mr. Coteau, point of order.
Come on, you know, we're voting on amendments here. You're allowing
You're voting
the
on
party
lines.
opposite to talk more about why we should, you know, have them focus on the amendment, not on why we should vote a certain way as individuals on this side. Please.
Mr. Coteau, I've been through many of these debates on bills, and in the course of debate in committee, people on either side of the aisle have tried to persuade the other side to vote with them. Many times I've tried to persuade the Liberals to vote with me, and contrary-wise, Liberals have tried to persuade me to vote with them. I see it as in order to make an argument to bring people over on a vote, and so I rule your point of order out of order. Any other debate, Mr. Broadnetti?
Well, I will not be supporting the debate, the amendment.
You won't be supporting the amendment? A recorded vote has been requested. All those in favor, please raise their hands.
Mr. Hillier, Mr. Nichols, Mr. Walker, Ms. DeNovo.
All those opposed?
Mr. Bertanetti, Mr. Coteau, Mr. Dillon, Mr. Sergio.
And by custom, unfortunately, I will be voting against this amendment. Shall Section 2 carry? Carried. Section 3, there are no amendments. Shall Section 3 carry? Carried. Section 4, there are no amendments. Shall Section 4 carry? Carried. Excuse me, members of the committee. Shall the title of the bill carry? Carried. Shall Bill 16 carry? Carried. shall I report the bill to the House? Carried? Carried. And that...
Mr. Chair?
Ms. DeNovo?
I just wanted to add a word. Kim Crater, the member from Niagara Falls, is not present but was a co-signatory of this bill, and I just want to mention his name into the record and thank him for his support.
Thank you, Ms. DeNovo. Just before we close out, because there will be people who will have questions about how I make decisions on casting vote, I need to read the notes from our standing orders. In general, when a committee cannot by a majority decide a question, the chair has no obligation to decide on the committee's behalf and should avoid doing so. The chair should vote in any way that extends debate, maintains the status quo, for example, leaves a bill in its existing form, or offers the opportunity for the committee as a whole to further debate and decide the matter. For those who are not familiar with the way these committees are structured, I, as the deciding vote, follow a tradition and rules. If, in fact, this bill had not been, if this bill had a final vote in which it had been tied as to whether the bill would go forward, I would have had to vote and would willingly have voted for it to continue to go forward to third reading. That's it.
Chair?
Now, we actually have done our business for the day.
There was one element of our business in the day that has not been completed.
And
that was the member for Scarborough Southwest said that at the end of this he would provide the rationale for the Liberal members in voting down every amendment.
During the committee.
Oh, he said he was going to do it.
Yeah, no,
Yeah.
I'll make a couple of comments.
do
First of
people
all,
want to hear from the member? Then we will hear from the member.
there is a bill in place that was Bill 132 that was put in place. I, as a government member, I can't speak for all of them. I support the original bill. This new bill that was created, we did not vote against sending it to the House. We just voted against the amendments. So thank you.
Thoughtful reflection on those amendments.
This committee now stands adjourned.